YouTube channel. Also, if anyone is joining live, you can ask your questions. I'll try to answer as many as possible. So the first question I have is from Sajid 4 days ago. Hello, so I have recently submitted my application for a skilled worker visa. I believe I will get my visa by February. So I can apply for my visa for my wife with the current salary threshold. Can I apply? Okay, so firstly, these questions have been asked repeatedly to me about the skilled worker changes to the dependent, whether dependent is allowed or not. So firstly, I would like to clarify is that, so it's this question is about dependents on skilled worker visa, since the government has declared that there will be some changes to the dependents, whether they will be allowed or not, from around April onwards, April 2024 onwards. The rules have not been created yet, so I cannot tell you exactly what the rules would be, but this is what they have indicated. The dependents not allowed on a skilled worker visa is only for the job categories. That's what the government, that's what the ministers and everyone has been saying. That's what is in the news, and that's what they have made in their fact sheet as well that I have read myself. So it doesn't apply to all the job codes. So if you are a chef or someone else or nurse, uh, they are specifically talking of stopping the dependents for senior care workers or care workers. They are specific job codes in the, if you look for UKVI job codes for skilled workers, you will have a lot of occupations in there. So to the best of my knowledge and what is in the news and what the ministers have said is they have a problem with the dependents on the care worker visa, on the senior care worker visa. So one of the two. They don't have a problem with the dependents of any other visa, any other skilled worker visa for other job codes. So uh, this is a common question that I'm getting. Everyone is asking me. So if you're not, if the main applicant is not under one of these job codes, either the senior care worker or care worker visa, then the dependent changes will not affect you. So if Sajid, if you are talking of that you are in one of these job codes, your question is you get your visa before the rules change. So around February or so, you're talking of, will your wife be able to join you after the changes? So assuming that you are on one of these, say, let's say care worker visa or senior care worker visa, where the changes are going to be implemented, that dependents won't be allowed. Rules have not been made, but what has been said by the ministers on that, I am interpreting it. Then let's say the rules change on 1st of April. I'm just taking an example, 1st April 2024. You get your visa in February or anytime before that, your skilled worker visa as the main applicant. And let's say your wife's application is filed on or after 1st of April. So on 1st of, in my example, I'm taking the example as the rules change on 1st of April. Then if your wife applies for a visa on 1st of April or thereafter, then she will be impacted by the rules and she won't be able to join you. So that's number one. If she applies on 31st March or earlier, then the current rules will apply and she can join you. So that's how I can take an example and explain. So I know everyone is asking this question, so that's why I wanted to clarify. The rule changes for dependents are only for specific job categories, senior care worker visa or care worker visa, not for across the board for all skilled workers, number one. Uh, and secondly, the date of application will apply. So in my example, as I said, if the rules change on 1st of April, dependents are not allowed on those job codes. Then if the application, date of application, that's when the visa application fees is paid, IHS is paid, visa application fees, that's the main one. IHS is paid first, and after that you pay the visa application. If you do that on 1st of April or thereafter, if the rule changes on 1st April, that's my example I'm taking here, then your dependent will not be able to join you, your wife will not be able to join you. So that's so I really have a like question. Asylum seeker is allowed to change status to skilled worker provided you do have section 3C leave. So if you have section 3C leave, that is something that any lawyer can tell you after they take all the facts of your case. You should take immigration advice on that. If you have section 3C leave, then you may be able to switch to any immigration category, not just skilled worker. It can be spouse visa or any other visa category. You can only switch if you have section 3C leave. So that is a technicality. The lawyer has to take all the information from you when you arrived, when you filed, etc., etc., and what is your current status, and only then they will be able to advise you. Yes, you can switch if you do have section 3C leave. That is, your application is pending and it is filed within time and all of those things. So speak to an immigration lawyer. Only then you can switch if you have section 3C leave. So next question that is on the comments is can I live in a relative's house on a skilled worker visa without paying council tax? Will it affect? So yeah, these are common questions I get. Accommodation is not a part of skilled worker application. So the question is the individual is on a skilled worker visa and he or she wants to live with relatives without paying council tax. So you don't have to pay anything. If you so there is no requirement to pay any rent or council tax. It can be friends or relatives' house. That is perfectly fine. For skilled worker visa, there are no documentation required that you need to be paying rent or council tax in the UK. You can be living with family, whatever that is. So these are not the ILR requirements for skilled worker. Don't need any of that. You can live with your relatives. That is perfectly fine without paying council tax or without paying rent, whatever that is. And it will not affect your indefinite leave to remain application on skilled worker visa. Next question from the same person. Can relatives? Okay, I've answered that. Can I apply in 2025 December? So, okay, the question is on the youth mobility visa. So I'm assuming you are want to file an application for. So changes coming for youth mobility visa. Australians will be added from January. Can I apply in 2025 December? Yes, if you do meet the eligibility requirements, the age and all of that mainly for an Australian or whichever the nations are joining in January, as per that video. So you can apply for the youth mobility visa from December 2025. That is perfectly fine. The rules are going to change in January 2024. So by 1 year, definitely the same rules will continue. So next question from Singh V Vikram. Next question. Skilled worker visa. I have arrived in London 665. I have a wife and two kids. All are dependent on me financially. Can I apply under dependent visa? Also, if they do not remain in the UK, yeah. Okay, several questions. So this is about skilled worker visa dependents. So you have a skilled worker visa. You already came to the UK. You have wife and two kids. The kid who is 21 years old will not be able to apply as dependent. The requirement is the person should be under 18 years of age. Only the child who is 16 years of age and your wife will be able to apply for the dependent visa. All are dependents on me financially. That doesn't matter. The 21-year-old will not be able to join you as a dependent. There are some live questions, but I'll complete this one. Can all apply under dependent visa? The 21-year-old will not be able to apply. Others can. Also, if they do not remain in the 180 days, is it okay? No, everyone has to meet the 180 days requirement to qualify for ILR. It is not okay for them to remain outside the UK for more than 180 days. That will break their continuity of residence. I hope it won't impact ILR process. No, it will affect their ILR process. Another question is for my elder kid who is 20 years. The answer to a dependent visa is yes. Internship. No, the answer to a dependent visa is no. So I don't think other questions are relevant. Okay, if the answer to no, then what is the other way for her to come to the UK? Yeah, she has to apply for her own in her own right. Whatever, if you get a student visa or whatever, as soon as the person is over 18 years of age, they are considered independent. They cannot be attached to your skilled worker visa as a dependent. So whatever student visa or whatever other options that you can consider, if she's a genuine student, wants to study and all of that, you may get her onto those visa options. So live questions, Mohammed. प्री सेटलमेंट है और मैं overstay हो गया वो पाकिस्तान आया ये दूसरे हो गए और कहा दिसंबर में करता हूँ इस मैं वापस यूके आ सकती हूँ. So Muhammad Ahmed, so you had pre-settlement. I don't know how you overstayed. So I think you overstayed outside the UK. That's what you mean. More than 2 years you lived outside the UK. So is your pre-settled status lapsed? That's what you mean to say. That's how I understand from your question. If that is not correct, you can clarify with further writing. You can come to the UK, but the only thing is, Home Office has not curtailed anyone's pre-settled status. To the best of the information that I have from Home Office, that we lawyers have, they have not yet come to the curtailment. But by operation of law, I would say, as a lawyer, I would say your pre-settlement settled status is lapsed. You may not be able to. It is no longer valid by operation of law. Home Office will not come and cancel it actively. They may come to it in future sometimes, but I don't think it will help you Yeah, at any time you are assessed, yeah, your pre-settled status may be cancelled and you will never qualify for settled status also. So if you live outside the UK, you are pre-settled status, you left the UK for more than 2 years, just by operation of law, that leave will be deemed to be cancelled, or that is lapsed. Lapsed is the technical word. So next questions, ILR requirements is only last 6 months pay slips. ILR requirements, are you talking of ILR requirements? I'm assuming for skilled worker visa, it's not even last 6 months payslips. The form asks for latest payslip issued within 31 calendar days, I think so. Yeah. So you only need one payslip. That's what the ILR requirement is. But I'm sure Home Office will get to searching the NI records and all of that of your past employment. Slowly they will get to doing that because there is a lot of fraud happening. The Home Office hasn't changed the form yet. It still says you have to give only the latest payslip. You don't need last 6 months payslips also. Uh, Mainly it depends on the letter from the employer. That is the most important one as of today. But slowly, I think Home Office may change the approach considering whatever problems are going on in the skilled worker area. Okay, so Senturam, a long time, 16 weeks for the Home Office to correct it. Should I wait until they correct the name to apply for costs? Apply for costs. Sorry, I don't understand your question. What are you talking of 16 weeks for Home Office to correct what? Please clarify your question, Senturan. Okay, next question on regarding the veto also, does it also impact the extension if the stay in the UK is less than 180 days? What are the maximum options allowed on the okay. So I'm assuming because your previous question was for a skilled worker visa. So this is also your question is regarding the skilled worker visa 180 days absence. This video that I have there on the channel, does it also impact in the extensions in if the stay in the UK is less than 180 days? No, extensions you can keep on extending the skilled worker visa. The 180 days absences don't matter extensions. The rule for 180 days, you cannot be outside of the UK for more than 180 days in any 12-month cycle, only applies for indefinite leave to remain. Okay, so Senturan, there is a spelling mistake in the name of my business in the sponsor license. Yeah, so a long time, 16 weeks for the home office corrected. Yeah, 16 weeks is a standard processing. If you are, I don't know what are you trying to do, should I wait and until then correct the name to apply for costs? It seems like a long time since for the home office to correct it. Wait, this spelling mistake. So you, if you can give me some details. So you applied for a sponsor license with an incorrect name or a spelling mistake on the name. I'm not sure how they would because usually they would always look at the company's house, your certificate of incorporation and all. But anyways, all those corrections, certificate of sponsorship, you are applying for it. It's minor correction. Yeah, if you can please clarify if it is the first time you're assigning a course or you're it's an ongoing sponsor license for a long time and some if it is a new license, just let me know that then I can clarify the answers into them. If it is a very new license, it is the first time you're doing this, assigning a course and all of that. Okay, Naveen Kumar. So first time you got a sponsor license and there is a spelling mistake. So whose mistake is that? So home offices or yours? Can you state that first? I overstayed for 3.5 years, left the country in my own expense. I did my 1 year and apply for dependent visa. I overstayed for email twice without additional visa. Okay, home office mistake. Then I think you can assign it. If you have a lawyer, maybe speak to them and yeah, they should be able to advise you. But if I was a lawyer I am representing, I would explain it and definitely I would go ahead with applying for certificates of sponsorship, or if I already have the allocation, I would assign it and go forward. If they have made a mistake, yeah, so it's not your problem. But if something is wrong on your side, I don't know the exact facts of your case, but if it is home office mistake, then if I am representing you, I would have definitely gone ahead with the normal business operations for the sponsor license, applying for costs, assigning costs, whatever that is. You can go ahead. But then, yeah, if you are doing it yourself, you should be careful. Usually speak to a legal advisor and do it through them. Yeah, so Naveen Kumar's question on the comments is, I was stayed for 3.5 years, left the country, my expense completed. So someone overstayed. The question is, the individual overstayed for 3.5 years, then he completed the 1 year ban period. If voluntarily after you voluntarily return the UK after overstay, 12 months is the minimum waiting period to apply for any UK visa. You return at your own expense, that's fine. You applied for a dependent visa. So I'm assuming dependent of a student visa or dependent of a skilled worker visa. and you got a straightforward email, not straightforward email. Yeah, not straightforward email is very common in scenarios like yours. They want to investigate everything. They will go into the relationship side, whether it is genuine. They will see what other breaches you have done, you worked illegally. They do a lot of research. It is a common thing anytime. I have always seen this. Usually, when you file, when you are an overstay, always file it through lawyers and all. The lawyers usually, this is what we do. I don't know about others, but this is what a lawyer would do. They would go into your overstay, explain it, attach the law aspect of it. For example, 3.5 years overstay, you already spent, give evidence of that you left the UK, why you overstayed, whatever reasons you may have, you filed an application, etc., etc., it was delayed, you withdraw it, there was an appeal, anything that has happened on your history. Try to clarify all the facts of the case that happened in the past. Try to make it genuine by giving the facts of the case. You can just, I know you may just say you completed 12 months of the voluntary ban period and voluntary returns ban period and all of that. But yeah, that is not how it should work. Ideally, whenever we represent, we always explain the facts of the case, and that's how the case working will usually expedite it if you given the reasonable facts of the case. Even if it is a mistake, we have to come clear and say that it was a mistake of the client. We have advised them. Whatever are the facts of the case, whatever are the truths, you need to come forward with that. Just not make an application. Also, about the dependent visa side that you applied, it's not even a main applicant, it's a dependent. The relationship, I'm not sure how much of evidence you have given about the relationship, how long you've known the person, any cohabitation evidence, if you live together or you just got married, how you met the person. They will investigate on all these things. They want answers of all these things. You should always front load all these evidences if you are doing this application. So I'm not sure how much evidencing you have done or you done it through a legal rep or not. So usually we always front load all this information about the overstay, the gap period of 12 months, and also the relationship, which is what they will always be concerned about, that you are trying to come back to the UK. This is the first assumption that they will have, that your relationship is not genuine, and that's the point of starting point. That's how they would look at it. That's not in the rules, but that's human behavior. That's what they do. I understand from previous replies or questions that I got from Home Office whenever I have done any overstayed individuals applicants. So we always go forward with more information and more documentation. Okay, Nishan, yeah, that, so to answer your question, yes, if you overstayed and it's you completed voluntary period, dependent visa, it may take some time, but yeah, that is a common email. Your application is not straightforward. We need so more time to consider. It will not be decided in the normal timelines and all. It is a common one, and you don't need to worry about it. They will take some time to investigate. You need to give the time. Don't force them to make a decision. Yeah. Okay, Nishan, I applied for healthcare visa inside UK on 26th of July. So it's been more than 5 months, but I didn't get my visa yet. Got an email then. They scheduled an interview on 12th December, but didn't get any call. What should I do? Schedule an interview. So they scheduled an interview. Did you attend the interview or did they cancel the interview? Can you clarify that for that skilled worker, healthcare visa, job code that you applied? You have not got a decision. So Nishan is saying you applied on 26th of July till today, no decision. 12 December interview was scheduled. Even I'm not able to do any job since then. Who canceled the interview? Did the Home Office cancel the interview or what happened? Or you didn't go? Didn't get any call yet. So they said then they scheduled interview on 12 December. So when you say scheduled interview on 12 December, what's the interview scheduled on 12 December? Can you clarify that? Or they said we will interview you and we will get back to you by a call if you are stating they never called you. So they said that they will schedule an interview, but they never scheduled an interview. Just clarify that. I will take Tahir's question once I complete yours. So So if Home Office has withdrawn, yeah, just clarify that, Nishan. By the time I will take other answers. Hello, sir. Did Home Office not interview you? They decided not to interview or whatever is the thing. So yeah, they will, if they have withdrawn their decision to interview, they may make a decision without that. It may not necessarily be a positive decision. It may be whatever the decision. Let's say the sponsor lost the license, whatever happened. So or they have decided that it's a genuine case and they want to issue you. Yeah, but they will usually give a decision in about 3 months time. That's what I have seen anytime they are interviewing. There is some issue, definitely. They have kept your application on hold for 6 months or so. They, at the end of almost 6 months, then they are definitely investigating the sponsor at the other end, I'm pretty sure, or maybe other applicants of the same sponsor. So they don't trust that it is a genuine vacancy or there is some kind of fraud going on from the sponsor side or overall. So you need to give them some time to decide if they have withdrawn. Check with the sponsor if they continue to hold the license, is it downgraded, whatever the issues are. Get an update from them. If everything is fine, then usually they will give a positive decision. That's what I am assuming. I don't know the whole facts of the case, but that is what I think from experience may happen. Tahir Latif, hello sir. Do I need to book a venue before applying for UK fiance visa? No, you don't have to book a venue before applying for a UK fiance visa. Yeah, many times in the meetings with the Home Office seniors, even we had asked them, lawyers, we had asked them, even I remember I also asked some questions where what type of evidence are you looking for a fiance visa? And there is not much in the immigration rules. The only thing is you have to prove that the relationship is genuine. How much ever arrangement you have already made, let's say you already paid for any new or you printed cards or anything, show those things. You bought a ring or wedding dress or anything like that. Anything that has been done, definitely show it off. But there is nothing in the rules telling you that you have to do this or you have to do that. There is nothing in the rules. So yeah, so you don't have to book a venue. That's my answer. Yeah, Sanjay, next question. How can I switch visa from care home visa free? Visa free. Will you provide any help? Sorry, we don't provide any sponsors. We are immigration lawyers. I'm an immigration lawyer. We don't get into employment, recruitment, selling visas, and all of that. The only thing I can say is don't buy skilled worker visas and all of those fraud. Some of it will come hard slowly on those matters, so be mindful of those things. I cannot help with getting sponsors and all. We do manage sponsor licenses and everything for all the employers, but we don't provide any recruitment or anything like that. So just to clarify, next question is Imran Khan. I'm British by descent. My son was born outside UK. Now he's very punctuality minute. 30 months now. Born outside UK. Can I stay for the visa after 3 years? My husband is going to renew his visa after 2.5 years, then apply for citizenship 6 months. Yeah, so this is a common question that I get, and I've done many applications in the past in such scenario. So the question is, the individual Imran is a British citizen. Son is born outside the UK. Son is definitely under 18, I'm sure. And you got a child dependent visa, and your spouse should be on maybe on the spouse visa. So on for the child, you have the 30 months visa. Yes, I think you are under the 5-year rule. So the child is also a dependent on the spouse visa, I think so. Can I register him? Yes, after 3 years, you can register him as a British citizen. You don't have to extend that 30 months visa. So this is, yeah, so speak to an immigration advisor, but this from experience, I can say this channel cannot be taken as immigration advice. It is only for information purposes. But I have done in the past where individuals don't have any leave, like your child who is under 18, he, after 3 years of living in the UK, he can apply for British citizenship. I understand that at the point of 2.5 years, his visa will expire, the family route visa. But for the remaining 6 months period, he doesn't have to be legal in the UK. So technically speaking, I've done this many times. I know individuals who have also come as a visitor and all. There are non-visa nationals where they come as a visitor, and we have done applications for the children and all of that. So he doesn't have to extend his visa. He can directly wait for the 3-year period. As soon as he qualifies for the registration part, the child can apply. But remember, traveling outside the UK, coming into the UK will be a problem. The child may not be able to travel after that family route visa 30 months has ended till the time he gets the British registration. So while entering back in the UK, if he leaves the UK, that's the problem. Only the child may not be able to travel. If you are okay with the child not being able to travel during those period after the end of his visa, then you should be fine. You don't need to extend his 30 months visa, pay the very hefty immigration surcharge, the visa fees and all of that. He can just continue staying if you have already assessed all the requirements and you know that he qualifies for British citizenship registration within 6 months from that visa expiry. So you can continue without leave. He can continue without leave. Hi, thanks, sir. One more question. My wife is owner of the house, but she had her sister as a co-owner history. So do we need a cover letter from her? Yes, you should get a letter from whoever is jointly owning the properties. Yeah. So if your wife is your sponsor, I'm assuming, or is a part of the application, so the other sister who jointly owns should give a letter saying that I am happy for Tahir and my sister, my Tahir to come and live in this property, and Tahir and my wife, Tahir and his wife, or my sister, however you put it, and any children, if any children are also joining, uh, I'm happy for Tahir to come and live in this property once his visa is approved, something like that. Get a letter from the sister who is jointly owns the property, and a copy of her identification document, either a passport copy or a driving license. You get a driving license. Yeah, that should be sufficient, along with the land registry and council tax bills and all of those things. So next question, I want to apply for Mubashir. So I'm taking the questions on the comment section of the channel. Yeah, you can write the questions in your own time. I know that everyone may not be live. This video will be recorded, and all of you who have asked the questions on the channel can watch this in your own time. Okay, next, I want to apply for a spouse visa. What document do I need from my end and from my wife, and how much is salary required from now on? I'm a British citizen, past 20 years. Okay, Mupa Shari Jaz. Okay, so your question is you need all the information about spouse visa, what documents you need from your end, from your wife's end, salary requirements. If you on the search on our channel only, there should be a list of documents video. Also, if you go on the website, that list of documents video should describe all the documentation that is required. There are various videos on the spouse visa, salary require, how you are meeting the financial requirement, also spouse visa financial requirement, etc. Watch those videos. That videos, it's quite a detailed one. Or if you have the option of uh, getting an immigration advice from an immigration advisor, take the advice of a lawyer and get all the information. That's what usually people do. They talk to us for 30 minutes and they get all the answers. But for that, if you want the information from the channel, you can look for a list of documents for spouse visa overseas within UK. You have different videos on that. Also, if you go to the website should be in the bio link or whatever is there on YouTube channel. There is a list of documents you can download, and all some document formats are also there. So yeah, you need to do some exercise either on our YouTube channel and watch the videos, and go to our website and look for list of documents for spouse visa. Download those lists and work from there. Okay, Amit, ask your question. Next, how many payslips do I need for applying for spouse visa for my wife? So it depends on which category of financial requirement you are trying to meet. I'll just try to briefly answer. So if you have been with your employer for at least 6 months, last 6 months, then you can use the last 6 months pay slips, a letter from employer, and the bank statement showing the last 6 months payments. That's the requirement. If you have been in the employment for less than 6 months, then last 12 months of the same documents. Last 12 months pay slips, last 12 months bank statement showing the payment entries, and a letter from employer or employers confirming the employment. But go through the list of documents. I think you have asked this question. Okay, next. Okay, Amit, hello. You can ask your question live as well. I'll try to take it. Meanwhile, nav196. Okay, 5 page. Hello, sir. My question is, do I need to submit council tax document for UK fiance visa for my partner? Because I'm worried I have some remaining amount to pay, which I am doing slowly. Yeah, all the disputes between you and the council, whatever is the settlement of the money and all, home office doesn't care of that, because you are the sponsor. You are the British citizen, or you are settled in the UK. I'm pretty sure, because you are the sponsor. You can apply, but they always need the council tax document. You can put it. They are not trying to see if you have any. So the reason for home office to ask the council tax document is to see that there is enough and sufficient accommodation for the applicant. They don't care about your remaining balances with the council and all. If you have the whatever the settlement agreement, you should not worry about it. You can put the council tax bill. That should be fine. There is nothing in the rule saying that you have to have paid your council tax bill. That matter is between local authority and you. They can take to you to the whatever small claims court, get summons, take the money from you. That is a different matter. It's completely contracts issue and all of those payment non-payment issues. So that is not going to have any negative impact on the fiance visa if you are meeting the financial requirement and all of those stuff. So you should not worry about that council thing. Whatever, that is the agreement between you and the council, whatever disputes you have, whatever payment arrangements you have. So if you put that council tax bill, it should be fine. That is, they are mainly concerned to see that you have enough accommodation and all of that stuff. So next, applied for student visa September with the person email ID. Okay, so and cancel that in really. Okay, the question is about so nav 196. He filed a previous application student visa anytime in September 23, then cancel that application, withdrew that application. You used some your specific email and specific phone number. Now you want to apply for another application, whatever that visa application, email and our specific phone number. We use that whenever we create two applications for clients. We make hundreds of applications with the same combination. So the way the application works is as soon as you create an application, there is a link sent to you. That link and the password, they are the main combination how the application is recognized. So every application you create will have its own link to open it and the password. So the link and the password are the combination to open that application or to get into that application. So my answer is you can use the same email and the same phone number. It should not be an issue to make any number of UK immigration applications. Okay, no more questions yet live. Fatima, if a sponsor curtail visa and puts fraudulent case, can sponsor take back his complaint along with requesting curtailing visa? Yeah, so there are two things that you are asking. So this, you have a skilled worker visa, your sponsor, your employer has put some fraudulent case. That's what you are alleging. I'm not sure though that the fraudulent case is a different matter. Home office doesn't care about it. I don't know what the case is about unless I have the facts of the case. I cannot tell you anything about that. If it is an immigration fraudulent matter or you've done some fraud in the business or whatever they are claiming, but can sponsor take back his complaint? So I'm not sure where they have complained. So I'm assuming the complaint is made to home office. But where would they make a complaint? I'm not sure if there is any portal to make a complaint to home office. There may be some other type of complaints, whatever they've made under different laws that UK has. Maybe a criminal complaint, civil complaint, whatever you've done, embezzled funds, anything what they have done. But I don't think there is anything on the home office side. The only thing they may have done is they may have gone onto the sponsor management system and cancelled your visa, which means they might have searched for your certificate of responsibility. This is how a sponsor stops sponsoring a migrant. That's how they do it. That's how we also do when employers tell us we have fired this employee or we no longer want this sponsor this person or the employee resigns. Employee home office has to be reported. So within 10 days of the last day of work, the sponsor or their lawyer has to go into the system, inform them. So I think in your case, they have reported to home office that they are no longer sponsoring you. They can withdraw that reporting if it has not been actioned. It may not be usually if it is within those, yeah. If it is not being, when the sponsor goes on the sponsor management system, the reporting is there, they can go and withdraw that previous reporting if they want to. Whatever agreements you've made the sponsor, yes, they can take back that particular reporting, the reporting. So in my example, I'm assuming the sponsor reported and cancelled your costs, which means cancelled your visa technically, and then home office will cancel your visa. So the sponsor can go back and withdraw that previous reporting. It is possible. Employers do that. Sometimes employers end up canceling the visas, but then they decide for whatever reasons there is a discussion and agreement. We can go in and withdraw that previous reporting. So everything comes back to normal. Yes, that is possible. The sponsor can take back complaint in your words if that is what you, the words you are using. File page, the question how to prove our intention to home office that we are going to get married once I'm in the UK. Yeah, whatever photographs, however you might give them a statement from both the parties. Usually that's what we do, signed by both parties, either joint statement, individual statement, stating how you met, whether it's an arranged marriage through families or how many times you have met, how many times you went back to see that person, whatever are the facts of the case, give everything, put any evidences, copies of WhatsApp chats, etc. over the last whatever period you have been in a relationship, any flight e-tickets showing that you went back to see the person, If you all went on holidays, I'm not sure whether that happens in your culture. So any relationship proof that you can give of communication, spending time together, spending money for each other, sending monies to each other, whatever that is, put all of that, write in a statement and put it across. And if Home Office still wants to continue investigating, they can interview both of you and decide. So they have that option anyways. They can do that. So yeah, if you are not sure, and maybe speak to an immigration lawyer. This is what we also do. This is what many lawyers also do. Our also one of the main areas is spouse visa and fiance visa. You can book a consultation through our office or speak to any other lawyer and get advice on the relationship matters, etc. But that is my brief advice. Okay. Shinmad Bani, does the 20-day rule for the spouse visa apply to document evidence for accommodation? I don't think so. I have used within last 3 months also. But don't just give them very old evidence for accommodation purposes. Preferably, yes, if you can give within at least one calendar month any evidence or letters that have been written or anything. But for example, if you have a land registry which was issued 5 years back, I've used a land registry copy because that is a proof of ownership of the property. They can go and check on the land registry. Or if it's a tenancy agreement, let's say you signed the tenancy 1 year ago. You cannot have a new tenancy, obviously. So you can put that. So the 28-day rule doesn't apply, I would say, to the accommodation requirement. But for example, if you are giving a letter from someone, get it issued within at least one calendar month or so. It's just good practice within 3 months on a worst case scenario. Mm, what does leave that has been shortened means? Spouse visa, breakdown. Yeah, so I think your question is on the spouse visa. I'm not sure. Okay, so I think your question was on the spouse visa. So yeah, sorry, Fatima. Now I get your question. So your second question clarifies your first question. So Fatima was asking that her husband has curtailed, has written to Home Office stating that the relationship has broken down. That's what how I understand. And he's trying to. That is the first thing that he has done. That relationship has broken down for whatever reason, and he's tried to cancel your visa. But now you both have come to the agreement. If Home Office has already acted on that, and you usually get an email from Home Office saying that your leave has been curtailed and all of that. So yeah, if that has happened, then nothing can be done. You may have to apply for a new visa again if that has happened. Other than that, if the sponsor wants to take back the complaint, I'm not sure how to do that. I've never done that. I've never had sponsors do that. So, but then yeah, he can write to Home Office and see how he can withdraw that particular reporting that he has made that the relationship has broken down. And what does leave in shortened means? So what it means is if your spouse visa was granted for 33 months, which is given for as an entry clearance, let's say after 12 months, the sponsor, your husband, reports you that saying our relationship has broken down. Let's say after 12 months he does that. After 3 months of that, let's say Home Office pick it up. There is no guarantee when they pick it up. Let's say they pick it up after 3 months of that on the 15th month, and then they would curtail your leave, and your leave instead of ending after 33 months would end within the next 60 days. That's a letter will be sent. Usually an email is sent nowadays, or a letter. Later practice is gone. I think emails I have seen many times. So stating that your leave is going to end in next 60 days. So that 33 months is gone. You have to arrange either to apply for another visa or leave the UK within that 60 days period. That's called as cancellation of visa, shortened visa, curtailment of visa was the previous name. Okay, your account, my wife is pregnant. I am applying for UK fiance visa. So should I tell Home Office about my wife's pregnancy? Will that make my case strong? Yes, I think so. Yes, if your wife is pregnant, put the estimated due date, put any documentation you have from the hospital stating that you are the father, she is the mother. On the hospital documents, you usually have the name of both the parents and all of that. So do put all those evidences showing that you are the father. I know you cannot get the birth certificate, but at least on the documentation that you have currently with the hospital, put that showing that your wife is pregnant. That would help to prove that it is. It will help you to prove with the relationship genuineness. That will help. Yes, we definitely use that. Uh, Murali Krishna, how much fee will charge for the consultations or whether it's online? Our 99% of our consultations are online. It's a video consultation. All the fees information, usually write it and someone will send you the whole details of the consultation. I don't get into the bookings and all of those. So yeah, my staff will deal with that. So if you just write an email or call the office, yeah, you'll get the information. For the consultation. And Samir, when will the new rule start in UK? Yeah, rules have not been published. Which rule are we talking about here? The student visa rules have already gone live, I think. But I think you are talking of the dependents not being allowed, skilled worker visa salary going up to 38,700, spouse visa minimum financial requirement going to 29,000 in the first instance. It will happen sometime in April. That's what they say. Rules haven't come to me yet. So, but sometime in April. Okay. Okay, thanks, Murli. Okay, next question. I'm on a 2.5 spouse visa and being outside the UK for 4 months and a half. Do I have to show evidence of reasons or absence when applying for extension? Yeah, so this is a common question I do get. So you are on a so you're on a spouse visa, that is you are in the first 33 months or 30 months, and 4.5 years you have been out of the UK. You don't have to give the evidence per se, but if it is a continuing event and these things are happening again and again, I think at the extension, to answer your question, I don't think you would need an evidence. uh, yeah, I've never given evidence for any of my clients, and home office never came back. But then if you have some evidence, you can write a statement and put any evidences. It just helps. It's good practice, I would say. The rules don't say that, but we always work with good practice and try to get a decision quickly on the application rather than getting an email saying that your case is complex and all of that stuff. So yeah, it's just to help the caseworker with the case. Always give some statement saying that I was out for whatever reasons you were, and give any evidences, e-tickets, any problems, medical reasons, someone was sick over there, etc., etc. How old, like question, how old should be the documents before submitting the application? Which application are we talking about? Yeah, usually the pregnancy documents, yeah, since the time your wife has been pregnant, any documentation from the first date, you get something, you get an estimated due date. From that point till today, whatever evidences you've got, you can get a latest letter from the doctor stating the pregnancy, etc., your involvement, or you are the father, whatever that is. So any documentation works. There is nothing in the rules saying that you have to give any specific document. Next question, Samir. Payslips, bank statements. Yeah, for payslips, bank statements, spouse visa, and all, just either speak to an immigration lawyer, get an advice on that. It's a long discussion of 30 minutes minimum. That's what we do. Either you can book with us, go to another lawyer, or if you want to do the research on our channel, there is a list of documents for spouse visa. Overseas fiance visa is the same list. Go through that, watch the video. On our website also, there is a list of documents. The same list is discussed on the video. Go through all those things and you will get an idea. It's a long discussion. I cannot take that here. So, Samir Brother, is tenancy agreement mandatory when you apply inside UK spouse visa? If you have another address proof. Tenancy agreement, usually accommodation. Yes, they would need to see some future accommodation. That's what they care about. So there are two things with the tenancy agreement. If you're trying to show that you have been living together in the past 2 years or past 6 months or whatever that is, yes, you can use tenancy agreement or any other evidence as the cohabitation evidence. Second side of it, from the date of application, you are saying that this person, the applicant, is applying inside the UK. Whenever they get the visa, they should have accommodation to live here. So that's the second type of it. One is the cohabitation side, which you can use by any other address proof also, council tax, other letters, HMRC, NHS letters, whatever that is, at the same address. That is the cohabitation side. But if you are showing accommodation, there is enough accommodation for the applicant, I would say yes, a tenancy would be required, or whatever that is. It can be a single page tenancy. I have worked with one page tenancies also, where a room was shared with a person, where the couple was sharing a room and all of that. But some sort of a document would be expected from you to show that the person has enough accommodation. So tells documents. Okay, okay, all the questions done. I will take this question on hmm, Farhad. I have passed my dissertation, but exam what is saying Saturday. Something how you guys going to is the next time that my exam will change the marks. Is that exam? Okay, so the question of Farhad is student visa exam board is going to sit on 25th December and your visa is going to end on 30th January. So worst case scenario, you have to file for the next visa, whatever that is, latest by 30th of January. And any chance that exam board will change marks? I'm not sure. You need to speak to your exam board. I cannot tell you. Is there any chance that exam board will change the marks? You need to speak to the exam board or others. I am not qualified to answer on that. I want to apply for the visa on 15th of January. If your date of application is before, I'm not sure what visa we are referring to here. If it is a skilled worker visa, so if you are applying for a graduate route visa, I think you can apply. I know you want to apply on 15th of January and your visa is expiring on 30th of January, but you will get a decision on 25th of January. So technically, two dates matter for me. You are applying on 15th January and your result will be out on 25th January. That should be fine because by the time your application is decided, Home Office will speak to your college or get the confirmation whether you have completed that course successfully. If that is a PSW visa, graduate route visa you're talking of, I don't think you're talking of any other visa over here. Yeah, but if because you've not talked of the certificate of sponsorship or anything like that. So yes, you can apply before the fees increases and because your result will anyways come on 25th of January, which is just 10 days after you apply the visa. Okay, or OC1 document necessary or land registry. I'm not sure what is an OC1 document. Land registry is enough. I've used every time I've used land registry and council tax bill usually. That is the combination they want to see, not just land registry. So should I go to not make tenancy agreement or can I make with my landlord by myself? Yeah, I think the landlord and all speak to your landlord. They should also have a common tenancy agreement, or you can do it yourself. You don't have to go to a lawyer to make a tenancy. It's a contract between you and the landlord. What you decide, there are common terms. I think many times people just go on Google search for some tenancy. There are some automatic zip law and all of those law things where they allow you to download those documents. I think you can take a standard format and download and sign it off if both of you agree to the terms. Okay, you don't have to go to a lawyer. It's a contract between you and the landlord. So you can make the tenancy between you two. Next. Okay, Nadia, hello. Mm, next question. Okay, very best. Do I need home report to prove the how many rooms and no, you don't need the home report. There is a video. If you search for what is the video name, I will tell you. Don't waste your money on property accommodation report. Search for that name. Don't waste your money on property accommodation report. I have made a video. I've explained on a board everything. You don't need the property reports. Don't waste your money on all those things. Okay. Uh, Nadia Iqbal, son, my son has British passport. We are on 10-year route. Can you apply for ILR? Son has British passport. No. Son having British passport doesn't give you any right to apply for ILR. You have to continue on your own 10-year route. Okay. What does the solution means? Sorry. Tahamois. Next question. I have a response business for the past 6 years. Wanted to hire a worker. Is there a minimum amount of funds? Okay. Next question is about applying for a sponsor license for a small business employer. For an employer who has a small business. So you have a small business for the past 6 years. You want to hire a skilled worker. There is, and you are asking, is there a minimum amount of funds uh, in your company account need to show for me to be eligible for a sponsor license? There is no such minimum amount, but home office would always expect to see what is your past performance. So if you have give them your past 3 years of tax returns at least, you should. I know many times people come, small employees will come, they've declared losses, they've had a profit reporting of £5,000 for the whole year, and they're trying to apply for a sponsor license. Home office may not accept such things because obviously you're making a profit of 5,000 or you're reporting a loss for last 2 years and suddenly you want to hire a sponsor. They would like to see other source of funds, whether venture capital is funding you or there is loan that has been issued to you or you have some personal funds, whatever that is. They will try to see the genuineness of the reason why you want a sponsor license. Or at least when you apply for the certificate of sponsorship and all of that, if you try to apply for an defined certificate. But usually, yes, home office would like to see some funds. You cannot go with zero funds. It need not be in the form of a bank statement, but it may be in a different format. It may be a credit letter from a bank, a loan from a bank, your own personal savings. It can be different type of funding. Businesses have different types of funding. So you don't have to have a minimum funds in the company bank accounts, but you should definitely have either some kind of a funding or some kind of whatever invoices, continuous payments coming in, or business generated, that is enough to show that yes, I can pay. For example, you are saying I'm going to pay a salary of 38,700 for this skilled worker. I'm just taking that new salary which will come in April. So if you are saying that I'm going to pay 38,700 to this person, your business should be able to generate that much money at least. So yeah, you can show it in any way. You can write a covering letter, explain whatever your facts are, and go with that. You don't need to have that 38,700 sitting in your bank account. Okay. Abhishek, so I will get sponsorship chef work visa in this month. If I get married in August, then can I bring my spouse here? Will the new rule apply to my... The chef visas will not be affected with the dependent changes. The dependent changes, I've explained this in the beginning of the video. Watch the video at the beginning also. I have explained in detail. The dependent visa changes that the government is stated in their fact sheet is that they care about the senior care worker and care worker visa job codes. They don't care about chef job code. So I don't think it will affect you. Uh, Next, Sami, my partner name is not in any utility bill. It's just my name. Will that be all right? We are applying from UK. I'm not. I don't have all the facts of your case. You are applying for the first time. How long you know each other? It's a matter for the lawyer to discuss. I mean, take immigration advice. Speak to an immigration lawyer and get advice on that. Give them all the facts of the case. How long you've been living together in a relationship, how you met, etc., etc. Then the lawyer should be able to advise you and derive documents from there. So you don't have any, yeah, you're applying for the first time. Yeah, so definitely speak to an immigration lawyer, take advice on giving all the facts, and then they may be able to explain you and give you some suggestions as to what documentation you can produce. Because in the first instance, the genuineness of relationship is always in question. They always do that, a check on that. So be mindful of that. Take an immigration advice from any qualified lawyer. You don't have to come to us, but yeah, whichever lawyer you go to. Next question, file page. We have looked at marriage certificate not proved from any country. So do we need to show for fiance UK visa? You can show it if you have done. I understand that whether or not it is legal marriage is considered as legal marriage, you can show anything to prove that the relationship is genuine. Yeah, if you already done a nikah as per your religious way, you can show that. It may not proven as you know, but if you have done a nikah in a country outside the UK, let's say you've done a nikah in Pakistan or India where it is legal, then you are already married. You don't need to apply for a fiance visa. You can directly apply for a spouse visa. If that is the case, I don't know in which country you have got the nikah thing done. If you've done the nikah in UK, that is not legal marriage, so that may not help. But if you've done in nikah in a country where it is valid marriage, like India, Pakistan, Dubai, any Middle East country, where yeah, so you can use that nikah as a marriage certificate. That is a legal marriage certificate, to the best of my knowledge. I have Muslim friends. I know, so it nikah, I know what nikah is exactly. I have attended many nikahs, so it is possible. So yes, you can use that if it is legal in that country as a marriage certificate. Then it is a marriage certificate. So Salman, we are in 10 years route. One son got British passports, and second son, 5-year-old, is eligible for ILR after 7 years old. Yeah, if the second son is born in the UK for the last 5 years, has been living in the UK, then yes, after 7 years, he can apply for indefinite leave to remain. Salman's question answered. Once, Abhishek, once if I receive costs from my restaurant, how much chances of visa? It depends on the genuineness of your visa, genuineness of the sponsor license. There are many factors. I cannot just say I don't know anything about your sponsor's case, whether you will get a skilled worker visa or not. Just getting a cost doesn't mean that. I have had previously only, if you see in this live, only someone asked the individual's visa has been on hold for 6 months. That's a care worker visa, but still, Home Office has a right to investigate anything. So whether you'll get a visa or not, that depends on the facts of your case. Uh, Intikhab Alam, hello, so I just wanted to ask you, I have 5-year Portuguese residency. Can I work in any other EU country? I cannot advise you on Portuguese residency rights. I am only a UK immigration lawyer. Sorry about that. Uh, no, we have done online nikah from local masjid. I am not sure if that online nikah is a valid marriage certificate. Yeah, then you may have to go for the fiance visa and you can use that online nikah as one of the evidences of your relationship to help with the genuineness proving. Okay, next question. If college discontinues my course, I get 60 days home office notice. Can and all me and my husband dependent convert visa only 1 month left. What I do? Okay, I think the question is about the individual has discontinued college has discontinued the course, reported you to home office saying we are no longer sponsoring the student. I get 60 days. So I'm not sure whether you already got it. So I'm assuming you got it. If you got 60 days, then within those 60 days, you have to switch to some other category of visa, or you, your dependents, your husband also. You can convert to whichever visa you are eligible for. Let's say you get a sponsor. I don't think you can get a sponsor because if you not completed the course, you most probably you may have to leave the UK unless you have any human rights considerations. Yeah. So within 60 days, if you have any other category of visa that you are going into, other than that, I think it is possible. Yeah. So maybe speak to an immigration lawyer. Yeah, I don't know all the facts of your case, but the law is as soon as your visa is cancelled, you get 60 days from home office. Within that, you need to switch to an eligible category where you qualify or leave the UK. So speak to an immigration lawyer and take advice on that, please. Uh, Nadia, my elder son has a video, so he's 11 years old. Your parents later file are being 10 years old. Okay, I think Nadia, you asked the question live. So, but still, I will repeat the answer over here. So, son has British passport. He's 11 years old. Parents are on the 10-year route. Parent, you are asking me, can parents apply for ILR? Are they eligible for ILR? No, parents are not. They have to continue under the 10-year route in their own right and complete their 10 years and then qualify in their own right after completing the 10 years on that family route. Last question that I have on the comments. After that, if I don't have any live comments, I will end this live. I am in need. I'm need help my girlfriend applying out of time that I won't explain, but it's hard. She live in England, 14 years, kids, 1 year. I am a status. Help, please. Sorry, I don't understand your question clearly, but briefly, I understand your girlfriend applying out of time. So I think her visa has already expired, whatever leave she had, and she's trying to apply out of time and she live in England 14 years, kids born here, kids born here. So if her kids are born here and if they are British, then she may be able to apply for a parent visa or something, even if that is out of time. That may be possible. Usually speak to an immigration lawyer, give the facts of your case and ask. If she has British children or settled children, she may be able to apply within UK some category of visa, usually the family route, parent route, etc. Other than that, yeah, that is the only possible option out of time. Other than that, it may not be possible to apply inside the UK out of time. So that is the only help I can give. Usually speak to an immigration lawyer, give them all the facts of your case, and I think parent visa is the only option. And if she has kids who are born in the UK and they are British or settled with indefinitely permanent residence, whatever that is, then she may be able to get some kind of leave being inside the UK, even if she is out of time. So that's from experience, but take advice. Okay, all the questions on the comments are done. Last question, a year live, sir. Can you also eligible for ILR after my son get ILR? Okay, what was your previous question? We are in 10 years route. One son got British passport. Second son, 5-year old, is eligible. Can you also ILR? No. Even if both your children, so the first one I think has got already ILR or British passport, it will not help you. You have to continue in your own 10-year route to settlement, complete your own 10 years, and then apply for indefinite leave to remain. Your son's getting ILR doesn't help you. Okay, that's the answer to Salman's question. All the questions answered. It was a live for 1 hour. I had proposed it to do it for 30 minutes. It went on for 1 hour. Anyways, yeah, I'll do next live maybe next week or so. I will be back in the UK. Currently, I'm still outside the UK. And yeah, see you all next week. And thank you very much. You can ask any questions in the comments on the YouTube channel, and I will take them in the next live. Parminder Singh, you just got one question. How long British approval take these days? I applied 10 December. If you are thinking of, you are talking of naturalization application as a British citizen, then about we are getting applications in between 3 to 6 months. That's what we've seen, around 3 to 6 months time. Okay, thanks, Salman. Abhishek, shall I fix my marriage date or not in India? My family is very worried about new law of showing 38K salary. I don't understand what you exactly mean. If you're thinking of getting married earlier, yeah, you can think of getting married earlier. But if you're talking of the spouse visa under the British immigration rules, uh, yeah, so I fix my marriage date or not in India. Family is worried. New law showing 38K salary. So for the financial requirement, the new law in April that's going to come is 29,000, not 38,000. That is going to be staircased in within 6 months. It will staircase to a 34,500 or something, and to 38,700. So just to clarify the first point for spouse visas, what the government has clarified in their fact sheet that I read last week, uh, the spouse visa minimum financial requirement will go up from 18,600 to 29,000. Yeah, that's what I remember, 29,000. Yes, if you are not able to meet that, then yeah, before the changes come into play, maybe get married or whatever that is. That is my advice. Yeah, I'm not sure what you mean by fix your marriage date, but yeah, if you are not married, maybe get married and apply for the visa. So, in my cost from my restaurant, how much chances? So, Abhishek Mathur, what are you asking? Shall I fix my marriage? I don't know what you mean by fixing your marriage date. Yeah, yeah. So I think you are the same one you were asking for the chef visa, right? If I'm not wrong, Bishak Mathur, can you clarify that? It's one she was chef. Yeah, Abhishek Mathur, again to clarify, chef visas will not be affected with the dependent changes. If you're worried about that, I clarified that before also. I'm repeating that. Okay, I will not repeat myself again. I need to have a phone conversation with you. Okay, just if you go on our website, there is an automated booking system. I don't think, usually I don't work on Saturdays, and I'm also not in the UK. I'll be back on Monday. So usually we'll get the calendar, and that's how you will be able to book it. Yeah, speak to my office colleagues and send an email or fill up the contact form on the website and go on with that. So yeah, for usually there should be our website, and there is a phone number. You can contact the office or fill up the contact form on the website and see. I usually don't work on Saturdays, sorry. These are the only lives I just do to help people in the night times and different time periods. But yeah, usually paid work I don't do out of time. Only this YouTube channel I do out of time. Okay, so Abhishek Mathur, yeah, I don't. This is what I'm repeating myself. Chef work visa will not be affected. Chef job code, Home Office doesn't care about at this point of time. So they are not going to change the laws of the dependents for the main applicant who is a chef. So that's my again the same answer. Okay, so you don't need to worry about it. And thank you very much, everyone. Now I have to end this. I need to sleep. 11 o'clock. Bye bye.